I just want to understand the impact of your order. Is it at the level of a court order? So if the order is issued, does it mean that it has to be complied with, and unless it is challenged? Is it at that level of a court order, or it's a recommendation or a suggestion, whatever the case may be? That's the first question. The second question is, in cases where the tenant is locked out and an interim order is issued, what happens then? So does it mean that the tenant then takes that order to the landlord, and then the landlord must open until the case is heard in 7 days or so, where the landlord will then be present?
Okay, yeah. Well, the status of the tribunal, I was planning to, there is another slide, but let me deal with it and dispose of it now. In terms of the Rental Housing Act, the jurisdiction of the tribunal is equivalent to that of a magistrate's court. So any order that we issue enjoys the same status as a judgment of a magistrate's court. So if we order, for example, Mr. Nkonzo, you're a tenant, you must pay 50,000 rent to your landlord because you're owing rental, that order assumes the status of an order of a magistrate's court. It's as if you've been to the magistrate's court, the landlord has been to the magistrate's court and obtained an order against you for 50,000 rand. Now, coming to enforceability, if you do not comply within the stated time and pay, we then issue what we call an enforcement certificate to the landlord in an original form, which has the official stamp. The landlord goes to the clerk of the magistrate's court. The clerk of the court opens a file, gives it a magistrate's court case number, and then based on the certificate, converts that tribunal order into an order of that particular magistrate's court and issues a warrant of execution in favor of the landlord, then goes to the sheriff of court, and the sheriff of court then executes. So the execution is exactly like any, and we do our enforcement through the magistrate's court after we're done. I hope that explains it.
Yes.
The lockout, yes, we grant an interim order because you know, it's an emergency. Persons out in the streets. So if we hear the matter in the morning, we would grant an order, restoration of occupation by 4 o'clock that same afternoon. What we do is we would serve that order by email on the landlord, if we do have the email address. We unfortunately don't have the capacity amongst the inspectors to go and serve the order. So what we would say to the tenant, we give you the original stamped order, you go and hand deliver this to the landlord, or you can use the services of the sheriff of court to serve it on your landlord. So it's by email, personal service by the tenant himself or herself. Alternatively, the tenant takes it to the sheriff of court and the sheriff of court serves it. Now, the implications of non-compliance is twofold. The one being, as I've indicated, once it's an order of court, and you face the prospects of contempt. In a lockout matter, the sheriff of court is authorized, if the landlord does not comply, to then go and restore occupation of the tenant. So he can take the tenant, if it's a new lock, he can break the lock because the sheriff has got that power, break the lock, put in a new lock and put the tenant back in again. The third consequence, which is a discretion we apply, is a lockout also constitutes a criminal offense, which carries a fine or a maximum jail sentence of 2 years because it's a contravention of the Rental Housing Act. We don't often order that investigation by the police service because it now becomes a criminal matter that you've contravened Section 16HA of the Rental Housing Act, which carries the jail sentence. We as tribunal have to refer that to subs for an investigation against the landlord. We only do that where we find an absolute recalcitrant landlord. We sometimes find landlords appearing. So they got short notice of the lockout, but they do come. And they just take an attitude to say, do what you want to, I don't care, damn. Some of them get sometimes very insulting towards the tribunal. Many don't understand the jurisdiction of the tribunal, although we explain it up front. But they just treat the tribunal with absolute contempt. And they boldly say to the tribunal, or issue as much as you want to. This man and his family is going to stay in the streets. Extreme cases would then make a third order. And the third order is that the matter be referred to subsequent investigation for contravention of Section 16 of the Rental Housing Act. So that's basically but remember, when the landlord doesn't appear, we grant an interim order, so you restore, because you've done an unlawful act, so you restore. When the matter comes back, we hear both parties. In many cases, when we hear both parties, the issue of outstanding rental arises and say, well, I did not do it for nothing. Rental is owing. And if in that hearing, the tenant admits and says, yes, I do owe, and there's an agreement on the amount, we would then also make an order against the tenant in the same case for payment of the outstanding rental within a specified time. So a lot of landlords do take advantage of that, because on the return day they come and we say to them, but you also have rights. It's not only the tenant, you also have rights. These are your rights. Do you want to, you have the right to go and claim your rental in a magistrate's court. If you want to claim it here, you're welcome to do so. Let's hear you as well. And we find in your favor, we will not put you through the inconvenience of coming back 2 weeks later. Let's do it now, finalize it. So we deal with all disputes between the two parties right away.
Okay. Chair, I see we've got probably 4 minutes now for you have to leave, and there are other questions. So you offered that if we want to invite you again, you are willing to come. This is very educational, I must admit. I was not aware that a landlord can go to the rental tribunal and lodge a claim by himself. But yeah, I think this has to be redone. I think let's just, in terms of the presentation, let's leave it here. But let's answer the other questions, and then I will organize with you and the attendees in terms of when you can come back again, so that we have enough time to ventilate all these issues and the questions that the audience might have. There's a question on the chat. What happens if the landlord is not available to receive the interim order after locking out the tenant? So for instance, you're saying it is sent by email and by sheriff, and the landlord can deliver, the tenant can deliver. So if the landlord is claiming not to have received the email, but is not physically available to then receive the interim order that's submitted by the tenant or the sheriff, what happens then?